A jury trial commences with the selection of the jury. A non-jury trial commences with the first opening address, if there be any, or when the first witness is sworn. A conviction and the sentence imposed thereon is a judgment. The only crime that can have a sentence of more than 1 year in jail is a conviction of a felony. The function of a bench warrant is to achieve the court appearance of defendant for purpose other than arraignment. Sentence means imposition and entry of sentence upon conviction. The local criminal courts and the superior courts are the criminal courts of New York State. In the case of a felony other than a Class A felony, a motion to dismiss must be granted when people are not ready for trial within 6 months. This is CPL. A jury trial commences with the selection of the jury. A non-jury trial commences with the first opening address, if there be any, and if there's not, when the first witness is sworn. A conviction and the sentence imposed thereon is a judgment. The function of a bench warrant is to achieve the appearance of a defendant for a purpose other than arraignment. Sentence means imposition and entry of sentence upon conviction. The criminal courts of the state of New York are superior courts and local criminal courts. In the case of a felony, a motion to dismiss must be granted when people are not ready for trial within 6 months. Those things that I just read do not apply when the defendant is charged with murder, manslaughter, or homicide.
And I have Article 100.05, commencement of an action.
In general.
Right. A criminal action is commenced by the filing of an accusatory instrument with a criminal court. If more than one instrument is filed...
Let me stop you because this is where it changed.
Oh, no.
Okay. A criminal action...
Okay, go ahead.
It says, a criminal action is commenced by the filing of an accusatory instrument with a criminal court, or in the case of a juvenile or adolescent offender...
Or in the case of...
A juvenile
or
adolescent offender,
or
other than...
I spell adolescent, ADD.
And you'll remember
adolescent, I put ADD offender.
Okay. Other than an adolescent offender charged with only a violation or traffic infraction.
Oh my God! Wait, I gotta get that. Wait.
Or traffic infraction, the youth part of the superior court. And if more than one such instrument is filed, it starts when the first one is filed. The only way in which a criminal action can be commenced in a superior court is when the grand jury votes an indictment. Otherwise, it has to be commenced in an LCC by an LCC accusatory instrument, namely a felony complaint, misdemeanor complaint, information, simplified information, I'm forgetting one, or prosecutor's information. Please don't fall over. Okay, simplified traffic information, written accusation by a cop or another public servant which charges a person with the commission of one or more traffic infractions or misdemeanors relating to traffic. Contains no factual allegations of an evidentiary nature supporting such charges. Serves as the basis for commencement of the criminal action, and also in whole or in part could serve as a basis for prosecution as an alternative to filing a regular information. Simplified parks and simplified environmental conservation information. Those are by police or public servant, charge one or more offenses but no felonies. And the rest of it is the same. Prosecutor's information is a written accusation. A prosecutor's information is a written accusation by a DA filed with a local criminal court, either at the direction of the grand jury or the prosecutor's own instance. Serves as a basis for prosecution, but only commences a criminal action when the grand jury refused to give the DA their silent indictment and told them to go file the prosecutor's information. Misdemeanor complaint hasn't changed. It's a verified written accusation by a person filed in a local criminal court, charging a person with one or more offenses, none that's a felony, serves as the basis for commencement of the criminal action, and only can serve as a basis for prosecution if the defendant consents. A supporting deposition, you have to request it within 30 days, and the cop has to serve it within 30 days, or at least 5 days before trial, whichever is sooner. And the court has to direct him to serve it on defendant or his counsel. The simplified information charges a misdemeanor. The court may allow defendant to request it. He has to make a motion asking for this. And he's not supposed to make a motion if more than 90 days elapsed from when he was supposed to come to court. These are the ones that have to be verified, and they could be verified in any of the following matters: information, misdemeanor complaint, felony complaint, and supporting deposition and proof of service can be verified in any of the following matters: sworn to the court in which it's filed, sworn to a desk officer in charge or a superior officer, and something about administer an oath before another public servant if he's authorized to administer an oath. Information, misdemeanor complaint, felony complaint, and supporting deposition or proof of service of supporting deposition may be verified in any one of the following matters: sworn to the court in which it's filed, sworn to the desk officer in charge or any superior officers where the instrument's filed by a public servant and the law gives another public servant the right to verify it, then they could do it that way. The form notice together with the subscription of the deponent constitute a verification of the instrument. And then 5 is notary public. An instrument specified in sub 1 may be verified in any manner prescribed therein, unless in a particular case the court expressly directs verification in a particular manner prescribed in said subdivision 1. Also, in a 100.40, it looks like they may have changed something because they have an effective section, but they actually only changed the title. And the only thing I really didn't remember from this is that if the cop doesn't serve the supporting deposition within the time period, that renders it insufficient on its face. The rules about amending an indictment also apply to amending a prosecutor's information. Superseding information and prosecutor's information. At any time before entry of a plea of guilty or commencement of a trial of an information or another prosecutor's information or another information as the case may be, another PI is filed in the same LCC charging defendant with an offense charged in the first instrument. Such first instrument is, with respect to such offense, superseded by the second, and upon defendant's arraignment, the count of the first instrument charging such offense must be dismissed. The first instrument is not superseded by any count that's not in the second instrument. At any time before a plea of guilty or commencement of trial of an information, the DA may file a PI charging any offenses supported pursuant to the standards in 100.40 by the allegations of the factual part of the original information and or any supporting depths which may accompany it. In such case, the original information is superseded by the PI and upon the defendant's arraignment is deemed dismissed. Okay, so I'm going to break this down one by one because this is what I think this is actually saying. Situation 1. I go to court, I am charged with a regular information, and I'm charged with assault and forcible touching. Then a new information is filed, and it's only charging me with the assault. I am still being prosecuted for forcible touching and assault. But the assault charge is on the new information and the forcible touching is on the old information. That first information, it didn't just go away because I got arraigned on a superseding information. Okay, situation number 2. I am charged in a regular information with 3 counts. I'm charged with assault, forcible touching, and aggravated harassment. Okay? So I go to court, I get arraigned, I'm facing these 3 charges. Then the DA files a prosecutor's information, which supersedes the original information. The prosecutor's information only charges me with 2 of the counts. It's just the assault and the aggravated harassment. The moment that I get arraigned on the prosecutor's information, the forcible touching charge is dismissed because that whole first accusatory instrument is dismissed. And let me repeat this. The moment that I get arraigned on the prosecutor's information, I am no longer being prosecuted for forcible touching because that first information, that first regular information is completely dismissed. Situation 3. This is situation 3, but I'm going to use the storyline from situation 2. I'm being charged with these 2 charges. I go back to court again, and the DA files another prosecutor's information. So this is the 3rd total accusatory instrument that's been filed against me, and it's the 2nd one filed by a DA. And I see it, and it's only got 1 charge on there. The only thing that it's charging me with on there is the aggravated harassment, which is like a bullshit charge. I'm all excited thinking, yay, I'm not getting charged with assault anymore. But that is not true. This is how I'm going to say it. The assault charge is not superseded. Only the aggravated harassment that they put in the second PI, that's the only one that's superseding something. So I'm still being charged with both charges, just with two different accusatory instruments. A misdemeanor complaint must or may be replaced and superseded by an information. So the only thing about 100.55 that's noteworthy is that an information, simplified information, PI, or misdemeanor complaint may be filed with a village court of a particular village when offense charge was committed in such a village. A felony complaint may be filed with any town court or village court of a particular county when a felony was allegedly committed in some town of such county. Such court need not be that of the town or village in which such felony was allegedly committed. A information, simplified information, misdemeanor, or felony complaint may be filed with a judge of a superior court sitting as a local criminal court when an offense charge was allegedly committed in a county in which such judge is then present and in which he either resides or is currently holding or has been assigned to hold a term of a superior court.